has the floor. Thank you very much. Good morning, everyone. I'm very happy to open this panel and next to so many experts I admire, and the members are really of high level. I would like to greet Dr. Michael Lang, Professor Humberto Avila, and Guilherme Galdino, and Fernanda Pereira and Isabel Derzi. Because of time constraints, I will pass the floor directly to Guilherme Galdino to moderate the panels. And I hope that you enjoy this morning. Thank you. Thank you very much. It's really a great pleasure to be here and participate in this 10th Congress on International Tax Law. I started in 2015 when I was monitor working with the clerical works of the Congress. I would like to thank Dr. Flavio Neto Schreier, and thank you for the opportunity to moderate this panel. Also, I would like to thank for the topic because these commentaries of the OECD and UN are really key to us. And usually there are some consideration on these provisions. And this, because remember, just to recall you about the first panel, he mentioned some commentaries of these two organizations. So now, according to the order that we had, it's good to have this panel with Professor Lang, head of Institute from the Vienna University of Economics and Business, Isabel Derzi, professor of the Federal University of Minas Gerais, Humberto Avila, professor and lecturer at USP, Professor Fernanda Menezes Pereira, doctor's degree from USP and federal lawyer, and Clara Gomes Moreira, doctor's degree from USP and a professional here too at IBDT. So now let's start with Professor Marco Lang. He'll be speaking about the relevance of this OECD and UN commentaries considering the Vienna Treaty and also European countries. So you have the floor, Professor Lang.
Yeah, good morning, ladies and gentlemen, dear colleagues. First of all, I'm very honored and pleased that I had been invited again to Sao Paulo. I think last time I was here 10 years ago, and I also had the privilege to attend the Congress, and it's great to see and hear how the Congress has developed and grown over the years, and I'm very grateful to my friend Professor Schreier and all his colleagues to invite me, and it's a great pleasure to see so many familiar faces here, former PhD students or LLM students and other colleagues and friends. Yeah, the topic I'm going to talk about is has been announced is the relevance of the OECD and the UN commentary for tax treaty interpretation. And this is not the first presentation on that topic, and I think it's not the last one. It's, I think, an evergreen, a very relevant topic, and you might recall when you think about yesterday's session, we discussed about the relevance of the OECD commentary in the context of CFC legislation. In the first panel, we discussed about the relevance of the commentary and the guidelines when we talked about transfer pricing. So there are a lot of different issues where this topic comes into play, and I think it's fair to say that there are no final solutions yet. And what's quite interesting about that topic, and that's why I'm grateful that I had been invited to talk about that topic, that there are always some new aspects, and I will mention them during my brief presentation. So there is a very interesting judgment of the German Bundesfinanzhof, the Federal Tax Court from last year. There is also an interesting judgment of the Swiss Supreme Court, also from June 23. There is a letter ruling of the German Minister of Finance. And last but not least, there is also a very interesting report of the International Law Commission from 2018, about Article 31, paragraph 3 of the Vienna Convention on the Law of Treaties, and I will come back to that because this is also very relevant for the topic. Yeah. Oops. Yeah. When we talk about the OECD, the OECD and the UN commentary, then we have to distinguish between two very different situations. I think one situation, and that's the easy one compared to the other, is that we have a tax treaty which was already concluded when a certain version of the OECD commentary or the UN commentary was available, existed already at that time. And the other situation is that we have an existing treaty and a new version, a more recent version of the OECD and the UN commentary. As far as the first situation is concerned, I think it's rather easy because I think it's pretty clear that if we have a treaty which is modeled after the OECD or the UN Model Convention, then it's kind of obvious that we should also take into account the OECD or UN commentary which existed already at that time for the interpretation of that treaty. And I think if you look at court decisions and look at literature, I think the only issue which might be controversial in that respect is if you look at the Vienna Convention on the Law of Treaties on Article 31, 32, under which paragraph the commentary is covered. And in my view, this is not a very relevant question because one paragraph doesn't exclude the other, so it could be very easy or could be very likely that the OECD commentary is covered even under different paragraphs of Article 31, Vienna Convention on the Law of Treaties, or on 32. So it's maybe an indication of a special meaning, paragraph 4, but it's also part of the context, and we can derive something for the object and purpose from the OECD commentary. So therefore, I think it's clear that the OECD commentary, that version of the OECD commentary is relevant. I think what's also important to mention is that the OECD commentary is just one tool for the interpretation of those treaties, because sometimes one gets the impression that interpreting tax treaty is not just interpreting a certain provision of a treaty, but interpreting the commentary of the OECD Model Convention, because there is so much emphasis put on the commentary. And I think it should be clear that the commentary might be part of the historic interpretation, might be part of the context, but of course there are other means of interpretation as well. There is the wording, there are other arguments derived from the context, from the object of purpose, and we have to balance those different arguments, and there might be quite often situations where we have a certain position in the commentary, but it's not reflected in the treaty itself, and therefore despite a certain argument or a certain position in the OECD commentary, at the end of the interpretation process, we arrive at another solution. However, as I mentioned before, what's more interesting at the end of the day are later commentaries. And I think here we can focus, as far as the Vienna Convention on the Law of Treaties is concerned, mainly on Article 31, paragraph 3, because this is more or less the provision which might justify, and we will discuss that in the next couple of minutes, which might justify to take into account later commentaries, because this provision is about subsequent agreements and subsequent practice. And subsequent agreements and subsequent practice may be taken into account for the interpretation of international treaties and therefore also for the interpretation of tax treaties. Yeah, and when we come to Article 31, paragraph 3, about subsequent agreements, then first of all it's important to mention that under the Vienna Convention on the Law of Treaties we have to distinguish between interpretation and modification. And I think from that point of view, or from that perspective, I think it's pretty clear that there have to be limits for interpretation. because you can also change the treaty as such, and this is dealt with under other provisions of the Vienna Convention on the Law of Treaties, but 31.3 is just about the interpretation. And then, of course, the interesting question is how to distinguish between interpretation and modification. The recent judgment of the German Bundesfinanzhof, the German Federal Tax Court I referred to a couple of minutes ago, puts a lot of emphasis on the wording of the provision. And I'm a bit skeptical on that. I'm not sure whether the wording of the provision does really limit the interpretation here in that respect, and in particular in the context of treaties, because as you all know, usually we have more than one authentic language for the interpretation of treaties, and we have also, as far as a treaty is modeled after the OECD or the UN Model Convention, we have also to take into account the English and the French version of the OECD Model Convention, even if those languages are not authentic languages. And as far as the UN is concerned, we even have 6 usually additional languages therefore. And therefore, I think if you really put a lot of emphasis on the wording, well, you either arrive at a situation that there are almost no limits because you have so many languages, therefore, and each phrase has been translated in those different languages, and they have, of course, not identical meaning. That's in the essence of different languages. Or if you want to find a common denominator of all these languages, sometimes the result might be even 0. So therefore I think in particular in the context of international treaties and tax treaties, it's a bit difficult to argue with the wording. And even more, I think what we also should be aware of, that there might be situations where it's impossible to stick to the letters of the law, just to the letters of the law, the wording. Just to give you one example in the context of tax treaties. We all know that the scope of a tax treaty is defined in Article 2 of the OECD Model Convention. And it covers also taxes on the total amounts of wages and salaries. Yeah? And in my country, for example, we have such a tax. We are not talking about wage tax as such. We are talking about taxes on the total amount of wages and salaries. And every tax, for every tax which is covered under Article 2, well, you should be able to find an allocation rule. But if you deal with such a tax and look at the terminology used in Article 6 to 21, you find profits there, you find remuneration, but in a different context. It's the remuneration of the employee. Here we are talking about a tax which is levied on the enterprise as such. We have payments there, but payments for students. So therefore, if you go through all the allocation rule, you would not find any allocation rule which would fit on such a tax. And therefore, I think prevailing opinion is in many countries that you have to cover such tax under Article 7. So you assume this is a profit, but of course it's not a profit. It's an expense at the end of the day from the perspective of the company, from the business. So therefore, I think the alternative would be to give up and not to apply the treaty. Also, the tax is mentioned in Article 2, which in my view would be an absurd result. So therefore there are, and this is just one example where it's impossible to stick to the letters of the treaty. So therefore I'm a bit skeptical on that. Maybe also one word in that context on distinguishing between clarification and modification, because you find that quite often in literature as a kind of compromise, that there are sometimes even courts and a lot of authors, experts who say, well, you can't take later commentaries into account in general, but if they just clarify the situation, then it might be possible. I'm very skeptical on that because I don't find that solution convincing at all. Because how do you find out whether a certain position in a later commentary just clarifies the situation? Well, from a logical point of view, you have to compare the position in the later commentary with the previous treaty, with the content of the treaty provision, and then if the position is identical, then it might be just a clarification. Yeah? But if you have already found out what the content of the treaty provision is, well, you don't need the later commentary anymore. And I think we all know from many countries, I don't know how the situation here in Brazil is, but from my own country, quite often the term clarification is used in legislative materials. And in my country, I know in 99 or 95%, to be fair, of all the situations when the term clarification is used, it's not a clarification. It means that the new law should be applied retroactively then at the end, and the legislator just hides that by using the term clarification. And I have the impression that this is quite similar in the OECD commentary. You find quite often the term clarification, and I think this is an impression of bad consciousness of those who drafted the OECD commentary. Well, what you also find in the judgment of the German Bundesfinanzhof I referred to from last year are to a certain extent constitutional considerations. So at the end, the Bundesfinanzhof is quite skeptical about the relevance of the OECD commentary, and as a result, I share that position, but I'm not sure whether all the arguments are convincing. And I understand that they have constitutional concerns because it's a question of separation of powers at the end of the day. The OECD commentary and also the UN commentary, but more the OECD commentary, is developed further by government experts in that respect, and they don't have the legitimization of the parliament for that purpose. So therefore there are constitutional concerns. However, I think this is a case where it's quite difficult to take into account constitutional considerations for the interpretation of the treaty. Because that would mean that you have one and the same provision under the OECD or the UN model, and therefore if you have certain constitutional limits in a specific country, then the provision of that treaty would look different than, or would have a different content than in the other country. And I think this is nothing we can assume when we interpret a tax treaty. So therefore, constitutional considerations, in particular, if they concern the OECD commentary and the interpretation of provisions which are modeled after the OECD Model Convention, I think there are limits, at least as far as the interpretation is concerned. Of course, it might be, of course, a court might have concern, but then I think it should not, those concerns should not be part of the interpretation process. It might be the result that the provision as such is unconstitutional then. And that might be true also for treaty provisions. Of course, different countries have different tools to handle such a situation. Yeah, but I think, and therefore at the end of the day, the German Bundesfinanzhof is, in my view, right, and the arguments are convincing. What we should take into account that the Vienna Convention on the Law of Treaties tries to give guidelines for the interpretation of all treaties, but of course treaties are different. We have WTO treaties, we have human rights treaties, and we talked about that during the last session, and we have many other types of treaties, and we have tax treaties. And I think what's quite common in many countries that there are high expectations about the predictability of the law in tax law, and there is a kind of strict interpretation of the rule of law. And I think this should have and could have some impact also on the interpretation of tax treaties worldwide. And that means that articles for only that reason already, Article 31, paragraph 3, as far as you try to argue that the OECD commentary is relevant under that provision, should have very limited relevance here, because I'm not saying tax law is special as such, but tax treaties are to a certain extent special compared to other treaties, and therefore there is not so much room for interpretation. Yeah, the next argument, I think, is closely related, has not been used by the German Bundesfinanzhof, but could have been used, that I think it makes a difference if two countries draft a tax treaty from the scratch, or if they incorporate and base their treaty on the OECD or the UN Model Convention. Because that implies that they not only want to simplify their treaty negotiations, but also they want to make sure that there is a common understanding of that provision. And I think that's nice for us tax lawyers and international tax lawyers as well, that we can talk about the same provision of the treaty between Austria and Brazil, or between China and Germany, for example. If it's modeled after the same OECD or UN model, then the interpretation is kind of identical or similar. And I think this is a value of those models, and therefore this should also be taken into account for the interpretation. Because if you would put a lot of weight on subsequent practice and subsequent agreements, and we're always talking about bilateral subsequent practice and bilateral subsequent agreements, if we would put a lot of emphasis on that, then we would have a kind of split interpretation, depending whether there is some subsequent practice in one country or there is not subsequent practice. So therefore, this is for me an additional argument why Article 31, paragraph 3 should have not much emphasis in tax law. Yeah, what's also interesting is, and I mentioned the report of the International Law Commission from 2018 about Article 31, paragraph 3, and I think this is quite an interesting report. It doesn't focus so much on tax treaties, of course. It's a very general report. But the International Law Commission takes the position that there might be treaty provisions, international treaty provisions, which have a kind of static understanding, and there might be some who have a dynamic understanding. And of course, it's a matter of interpretation to find out which provisions is more static and which is more dynamic. However, after having read the ILC report several times, my impression is that it's more a question what the ILC had in mind of new facts which might be established later on. And they use one prominent example of international tax law, a decision of the International Court of Justice on the San Juan River. I think it was a case between Costa Rica and Nicaragua, and there was a treaty from 1858 which dealt with the use of that river, and the river could only be used for comercio, for commerce. And then, many years later, the question came up when there were tourists and where there was tourism, whether Costa Rica is also permitted to use this river for touristic purposes. And the argument here, the court agreed because Nicaragua silently accepted the practice of Costa Rica, which might be an argument, but I think the main argument why there is a dynamic understanding is this is a new factual situation. In 1858, obviously, there was no tourism at that time, and then when tourism came up, then the question had to be solved, what does commerce mean at the end of the day? And they found out, well, commerce can be interpreted in a more broad view at the end of the day. So I think it has a lot to do with new facts. And interesting, the judgment of the German Supreme Court, which I mentioned also of the Swiss Supreme Court, which I mentioned at the beginning, is also dealing with that issue and referring to the ILC report from 2018, and saying that tax treaties have in principle to be interpreted in a static way. Only the terms profits, remuneration, and so on, so those links to the tax base, they have to interpret it in a dynamic way, which I think is a convincing solution by the Swiss Supreme Court. and the Swiss Supreme Court at the end of the day took the view that therefore only the version of the OECD commentary can be taken into account, which existed already at the time when the treaty was concluded. Yeah, another argument which was dealt with by the German Ministry of Finance recently in a kind of ruling. It was the question that the text, that the OECD commentary should be considered to be subsequent practice or subsequent agreement, because it's the officials of the tax administration who are sitting in Paris, as far as the OECD model convention is concerned, and are deciding on the OECD commentary. And here the German Bundesfinanzhof took a very clear view last year and said, well, they are acting on behalf of their countries, of their governments, but not on behalf of the contracting states. So if a German representative is agreeing to a certain provision of the OECD commentary, then he's not applying and interpreting the treaty between France and Germany. That's a different story, and therefore this cannot be taken into account. Yeah, also what's quite interesting, and here the Swiss court and also an Austrian court before that referred to that, under the what is subsequent practice and what is the conduct of a party. Of course, there are situations in international law where the head of state is relevant, where the foreign minister is relevant, where the prime minister is relevant. The finance minister is never mentioned in Article 7, by the way, of the Vienna Convention on the Law of Treaties. But what the ILC report also referred to, there was also a very interesting case about the pensions of UNESCO officials in France. They had not been taxed, and the argument in that case was that this is a subsequent practice because they had not been taxed. And the ILC concluded from that that it's the lower authorities which are relevant. At the end of the day, in that judgment, it was not considered to be relevant for the interpretation because the government protested against the subsequent practice of the lower administrative bodies. Yeah, but in general, and that's what the ILC concluded from that it's in general the local tax authorities who are relevant for the subsequent practice. It's not the Ministry of Finance. And that had been decided by the Austrian Supreme Court already 8 years ago as well. So it's the lower authorities. And therefore, if a government wants to argue with later practice or with subsequent practice, they would have to provide evidence about the practice of the lower tax authorities, which is close to impossible or impossible in many countries because you have tax secrecy, so they can't disclose their decisions in other cases to another taxpayer, and therefore in practice I think this is also one of the reasons why subsequent practice is not really relevant for the interpretation of tax treaties. Yeah, I'm behind schedule a bit, therefore I'm very brief. I think one other issue is also because we are talking about the Vienna Convention of the Law of Treaties. But the Vienna Convention of the Law of Treaties is on the one hand a multilateral treaty, on the other hand it's also consistent general law, but it's not above the other treaties. Yeah? So therefore it's not higher ranking than regular other treaties. And at the end of the day, each treaty decides itself how it should be interpreted. And in the tax treaty area, we have a specific provision, as we all know, Article 3, paragraph 2, about the interpretation. And that would be, of course, another presentation to talk about Article 3, paragraph 2. But if I just refer to the term context, and in my view, Article 3, paragraph 2 gives priority to the context of the treaty for the interpretation. So the question is, what is the context under 3.2? It's definitely more than the context under the Vienna Convention on the Law of Treaties, because the Article 31 distinguishes between context and object and purpose, and it would be ridiculous if the object and purpose should not be taken into account for the treaty interpretation. So it's definitely broader, but is it necessarily so broad that it also covers Article 31, paragraph 3? I would have my doubts. So therefore, I think you could interpret the term context in Article 3, paragraph 2, that it's broader than the Vienna Convention on the Law of Treaties, but not that it doesn't cover all means of interpretations which are mentioned in the Vienna Convention on the Law of Treaties. Yeah, to conclude, so I think the commentaries for several reasons do not really fall under Article 31, paragraph 3. However, I agree, and the Swiss Supreme Court has mentioned that as well. It's still possible to use later commentaries for the interpretation, but only in the same way as we use articles of scholars for the interpretation of a treaty. So therefore, at the end of the day, if a later commentary has similar relevance as an article written by Professor Schueri, for example, and I would even go so far that the commentary has less relevance than such an article for two different reasons, because first of all, Professor Schueri's articles are always very convincing. Also, we disagree on some issues, but I always find your arguments extremely convincing. And the second reason is that the OECD commentaries only contains positions, but no arguments. So therefore, you can't derive in most of the situations any argument why the OECD commentary took a certain position. It's just a compromise between the governments represented in Paris, but they don't come up with reasoning. And that's, I think, a very serious reason why currently, at least, later commentaries don't have much relevance. But maybe if other courts decide in a similar way as the Swiss court has decided, maybe this is an incentive for the OECD and in the future also for the UN to provide more reasoning when they change and develop their commentaries further. Thank you very much for paying attention.
Obrigado, professor Lang. Agora, para continuar, vamos passar a palavra para a professora Misabel, que vai prosseguir nesse debate geral, mais especificamente sobre o artigo 3º, parágrafo 2º, a regra de reenvio à legislação doméstica. Professora, tem a palavra.
É uma grande honra estar aqui, neste 10º Congresso Brasileiro de Direito Internacional do IBDT, USP, a convite da organização, especialmente do professor Luiz Eduardo Schueri. Saúdo a todos que compõem esta mesa, ilustríssimo professor Lang, que acabou de nos brindar com uma magnífica conferência, introdutória de todas as demais, que se seguirão. O professor Humberto Ávila, um titular de todos os brasileiros, também, não é, professor Schueri? A professora Fernanda, o professor Guilherme Galdino e a nossa presidente, doutora Clara Moreira. Saudação a todos desta mesa e àqueles congressistas que aí se encontram. Como já foi dito, vou fazer uma referência específica ao artigo 3º, ponto 2, da Convenção Modelo da OCDE e o seu correspondente dispositivo na Convenção Modelo da ONU. Artigo que autoriza, caso o acordo, a convenção, para evitar a dupla tributação, e estamos falando especificamente de renda, não forneça lastro interpretativo suficiente, omissões na definição de um termo ou de uma expressão, por exemplo, o lastro suplementar deve ser buscado na legislação doméstica, segundo esse artigo 3.2 feitas várias observações de hierarquia que se seguem. Antes, vamos fazer 2 observações introdutórias. A primeira delas, não interessa aqui discutir o que se faz classicamente entre teóricos do direito e filósofos, pluralistas e monistas. Nós sabemos que os primeiros filósofos pluralistas, que são a maioria, como Hart, veem o direito internacional e as ordens jurídicas domésticas como ordens jurídicas independentes, regidas por critérios, princípios e justificativas próprias, sobretudo regidas por critérios de validade próprios. Do outro lado, o lado oposto, o lado está com os monistas, teóricos como um conterrâneo do professor Lang, ilustríssimo Hans Kelsen, e Ronald Dworkin, que prestigiam a unidade do direito, sendo que o direito internacional e o direito interno são uma única ordem normativa. Kelsen trabalha a unidade pela norma fundamental pressuposta, e Dworkin, em caso de conflito entre essas normas, de um sistema e outro, trabalha pela integridade do sistema. Seja como for, como dissemos, isso não importa. A corrente não importa a corrente a que nós nos filiemos. Como mostrou e demonstrou o professor Lang, entre o sistema internacional e o doméstico, e esse artigo 3.3 é a prova disso, tem pontos de conexão importantíssimos. Né? Um sistema e o outro, não importa que sejamos monistas ou não, estão conectados. E o artigo 3º que vamos comentar é um exemplo dessa conexão. A segunda observação, eu vou apenas registrar rapidamente, é um alerta feito por Tom Ginsburg. Existe recentemente, isso é antigo, mas agora essa tendência está voltando, diz ele que a tendência autoritária mais recente de certas ordens jurídicas domésticas, essa tendência influenciará a forma e a aceitação do direito internacional. Se essa tendência cresce, a tendência autoritária, haverá, então, um declínio dos acordos e da força dos acordos multilaterais, das cartas de direitos universais sobre direitos humanos, que são uma conquista pós-guerra, e a recusa na aceitação das jurisdições dos tribunais internacionais. Segundo Ginsburg, países autoritários tendem a observar apenas acordos bilaterais, acordos de cooperação, sobretudo militar, tributos sobre tributos e executivos soft law. O perfil do direito internacional, então, sofrerá mudanças. E, com base nesses 2 focos, é que eu faço também as minhas considerações a respeito do tema a que eu me propus. Assim, o que dizemos e o que dissermos, ou a forma como interpretamos os acordos bilaterais, essa forma vai influenciar, no futuro, o perfil do direito internacional. Essas são as minhas considerações introdutórias. Passando agora ao artigo 3.2, os senhores veem que é um enfoque muito menor, é um desenvolvimento subdesenvolvido daquilo que nos disse o nosso professor Lang, que fez uma análise geral, né, da interpretação dos comentários da OCDE e da ONU e da jurisprudência das grandes cortes supremas e tribunais internacionais. O artigo 3.2, à vista de uma ausência de definição, claro, estabelece uma hierarquia. Em primeiro lugar, vai valer, e o professor Lang já deixou claro, o que está definido expressamente na Convenção, no tratado. Há uma força positiva desse tratado ou dessa Convenção, mas havendo, né, omissão. E isso, a vida é dinâmica, isso surge, às vezes, posteriormente. A definição deve ser buscada no tal contexto a que o professor Lang dá um sentido amplo. Ele já nos deixou clara a complexidade da análise do que é esse tal de contexto. E orienta-nos a que este contexto deve ser visto de forma lata, né, considerando o tratado em si, o texto em si, articulado, mas também o preâmbulo, os anexos, os documentos, nos comentários à OCDE. Se busca, no fundo, com isso, qual seria a intenção das partes. E a legislação da contraparte num movimento de reciprocidade, conforme comentários da OCDE. Agora passamos, então, se tudo isso falhar, se identificar realmente uma omissão no tratado e no contexto, ao socorro em relação aos procedimentos amigáveis, né? Bilaterais, que poderiam ter alguma força. Mas, se isso também não houver, nós descemos mais um grau nessa hierarquia e vamos buscar uma definição doméstica, tributária, contemporânea, relativamente aos tributos em foco, no caso, mais a renda, que vai importar. E se ainda isso falhar, vamos ao quarto recurso, e depois ao quinto. Ou seja, buscando a definição doméstica, tributária, de modo geral, pertinente a outros tributos, e, finalmente, a definição doméstica não tributária. Isto parece simples, mas os senhores tiveram já uma posição clara do professor Lang, de quanto simples é, às vezes, altamente complexo. Parece até a reforma tributária recente do nosso país, que diz que ia simplificar, mas como é complexa. Aqui, em tudo que é vida e direito, a complexidade é a mesma. Concordo com todos aqueles, e aí vou citar os clássicos do direito internacional, por exemplo, Klaus Vogel, o professor Lang e outros que dão à constituição das partes contratantes, nessas hipóteses de omissão, um determinado papel. Ou seja, se socorrer de legislação doméstica e, às vezes, de legislação infralegal doméstica, tudo vai depender da constituição, do direito constitucional doméstico permitir tal efeito. Se a Constituição do Estado contratante permite tal efeito. Isso é muito importante. Então, em texto de Vogel, por exemplo, relativamente ao procedimento amigável feito entre as partes contratantes, o direito constitucional doméstico pode exigir algum procedimento de ratificação da convenção se o procedimento bilateral for relevante. O professor Lang nos adiantou aqui como é difícil diferenciar aquilo que é um procedimento amigável meramente clarificador e aquilo que é um procedimento adicional modificativo. Se for um procedimento modificativo, no caso do Brasil, não há dúvida de que este procedimento amigável, assinado pelas partes contratantes, se converterá em um protocolo e deverá ser aprovado pelo Congresso Nacional, porque se trata de modificação da lei anterior. Então, nós sabemos que, em nosso país, um tratado, uma convenção internacional só entra em vigor se for aprovada pelo Congresso Nacional. E só uma lei modifica outra. Então, se o procedimento amigável adicional o exigir, como? Ele é modificativo ou não? Se for modificativo, não há dúvida, como aconteceu, por exemplo, no tratado com a Argentina, a propósito do serviço, não vamos comentar isso, mas só um exemplo. Esse protocolo adicional foi ao Congresso para ser aprovado. O mesmo se dá, né, com a doutrina do nosso grande professor Lang, que nos deu uma aula aqui, que eu vou estudar mais ainda e decorar. Savoir par cœur, professor, de coração. Né? A Constituição conta, sim. Ela é altamente relevante. No caso do Brasil, isso está assentado entre nós. Por quê? As nossas leis dizem, tratados e convenções internacionais, uma vez aprovados pelo Congresso Nacional, são vinculantes e suspendem a eficácia de toda legislação interna que lhe for contrária, que lhes for contrária. Então, isso é o que está escrito nas nossas leis. Mas, apesar do efeito dessa suspensão de eficácia, tratados e convenções internacionais em nosso país não revogam, não alteram, não reduzem as normas da Constituição. Este é um ponto assentado entre nós. Eu não sei se isto é universal em outros países, mas isso nós precisamos ter em mira. Né? Então, vejam bem, aquele ponto que o professor Lang levantou, importantíssimo. Qual é a diferença entre um adicional, um procedimento amigável que apenas clarifica, faz uma clarificação daquilo que sempre houve, daquilo que sempre existiu, e uma modificação? No nosso país isso é relevante, por isso que essa modificação em um procedimento amigável vai se converter num protocolo e ir ao Congresso Nacional para ser aprovado. E assim sendo, como toda lei, a Constituição veda tributos sem lei e majoração de tributos já existentes sem lei. Então, essas modificações não podem vir, se não forem ao Congresso e forem modificativas, elas não são aceitas, se elas vierem em detrimento dos direitos do contribuinte. E mesmo sendo aprovadas pelo Congresso Nacional, operam como uma lei nova, se forem adicionais modificativos. Então, a lei nova em nosso país, à luz da Constituição, tem que respeitar a irretroatividade das leis, tem de respeitar o leque de direitos dos contribuintes, inclusive direito adquirido. Então, penso, né, que eu não vou me alongar, já estou encerrando as minhas considerações. Muito mais poderia ser dito, mas eu acho absolutamente desnecessário, porque o professor Lang já trouxe para nós a alta complexidade desses temas, as discussões internacionais. No caso do Brasil, Tratado e Convenção Internacional não modifica a nossa Constituição. E eu estou atenta ao fato de que as relações entre o direito interno doméstico e o direito internacional são relações de conexão, muitas vezes estreitas. Estou mais atenta ainda àquilo que nos ensinou Ginsburg. Se nós interpretamos do ponto de vista doméstico esses conflitos potenciais entre essas normas de maneira autoritária, sem respeitar a separação de poderes e os grandes valores e princípios da nossa própria Constituição, nós não estamos desfavorecendo e prejudicando apenas um grupo de contribuintes. Estou convencida de que Ginsburg tem razão. Nós estamos e estaremos trabalhando para uma modificação intolerável do próprio direito internacional. Muito obrigada aos senhores.
Muito obrigado, professora. De fato, o artigo 3º, parágrafo 2º, é um artigo apaixonante, inquietante. Passamos agora a palavra para o professor Humberto Ávila, que vai tratar sobre a relevância de guidelines sob a perspectiva do ordenamento jurídico brasileiro. Professor, tem a palavra.
Bom dia a todos. É uma enorme satisfação poder me dirigir a todos vocês. Eu queria inicialmente agradecer a organização e faço na pessoa do eminente professor, meu querido amigo, professor titular Luiz Eduardo Chueri, autoridade em direito internacional, não só no Brasil, onde é o expoente máximo, como também em nível internacional. Quero cumprimentar a todos os colegas de mesa.
Every colleague at the panel, on behalf of Isabel Desk. I'm going to explain the normative strength of the OECD and UN guidelines. As you know, I'm not an expert in international law or international tax law. But I see that this is an advantage. Geraldo Taliba, former professor, full professor of this house, and an expert in tax law, gave very important contributions in administrative law. And Celso Antônio de Mello, an expert in administrative law, always asked him, but Professor Taliba, as an expert in tax, how can you contribute to administrative law? Well, this is exactly because I do not really understand much. And this is why I have a knife from a different perspective. So this is why those who are out of the jungle can see how the forest is. And Rubem Gomes de Silva is also my inspiration here, because even when he made things right, he was really right and precise in doing so. So I'm going to cover three aspects. The first one is a very brief analysis of what seems to me something ignored by internationalists. Not in the sense that you have to agree with me, but rather that maybe these aspects will require some reflection. The second topic in my presentation is the nature, the origin, and the strength of these international organization guidelines. And thirdly, also, I would like to go through what Professor Schrader has just addressed to you. After preparing very carefully my improvisation, he decided to give me a topic to speak about here. So, examining the international law in light of the domestic legislation and also other categories under which we, or with which we are used to handle. Something that calls a lot of my attention, after referring to all the panels and panels from other congresses in the same field, is an analysis that combines whatever it is and whatever it should be and what the person wishes it to be with what it effectively is, whatever is posed and whatever needs to be posed so that the wish of the person can turn into reality. So because I work with topics from the dogmatic perspective, I always try to separate what is Lara, the right itself per se, and what is referendum or what depends on the modification. I also try to separate what is in the scope of being from what they should be. So, what they should be, but they are not. And lastly, I'll always try to separate whatever is the reason, um, creed, a feeling, a personal feeling, and whatever is a reason, meaning an argument that has to be used to justify something, like philosophers or theoreticians in law, when they separate the context of discovery or a causal explanation of something and then context of justification. So whatever we need to do in a justifiable manner to convince other people. And what I have seen very respectively is that many times the same person, while speaking about the same topic, mixes everything. What they wish, may they mix that with what effectively is, and mix that with what should be, with what is effectively taking place, and their personal wish with what should be the object of a justification. You can see that I believe that all of this should require thinking again because, at the same time, in my humble opinion, does not really work when put out together. You cannot mix what the person is really doing and what they should do, but this is something minor. I believe that there are two main things that should be more important to be addressed, and they are those related to the nature of the guidelines and how they should be interpreted. With regard to the first topic, I would like to analyze the nature, the origin, and the quality of sources. And then I'm going to examine the third topic. Those sources are treated as being soft law. Why is it so? Precisely because they do not involve a sanction, directly speaking. So, assuming that this is true, maybe we also have to recall what a North American philosopher recently uh, deceased wrote in his book as a counterargument to the concept of heart concept. He wrote, "The strength of the right and the strength of the law, has consequences that should be minimally effective and duly understandable, and that they should be put into effect in the concrete world." What caused my attention to this has to do with the nature itself of the guidelines. But there is a second aspect that also concerns me, and this is about their origin. For someone like me who is a lawyer and works in controversies taken to a court, over 30 years of practice, I I think that these guidelines that are established by the executive branches usually have a very specific guidance. Usually, international organizations are composed of people connected to these executive branches. So must be highlighted. Usually, we say you cannot ask to the fox how you take care of the chicken, The chicken elect representatives precisely to make their representatives to vote on behalf of their interests. Because if you ask the fox how you take care of the chicken, you don't have to know what the answer will be. It will be, how can I eat the chicken as fast as possible? The third aspect to highlight has to do with the quality of the norms. I have a big concern on this. I'm just going to mention Article 29 of the UN Convention. And they state roughly this, that transactions will not be considered valid if possible, if reasonably completed in view of the facts and circumstances whose main objective is to obtain a benefit, except if it can be evidenced that the objective is compatible with the purposes and objects of the relevant positions of in the convention. Well, the purpose is really wonderful. But what is reasonable and what is relevant and what are the facts and circumstances that are relevant and what does the object and the purpose mean in the convention? All of these show that these guidelines have a very specific quality, which is precisely a high level of generosity, meaning lack of being specific with regard to what people should do or are prohibited from doing, and a high level of vagueness, which is the lack of precision with regard to what are the cases that fit into it and not fit into the guidelines. Of course, all of this causes an inevitable attribution of a high level of discretion to the authorities to define whatever should be done and not done. We who work with tax planning in Brazil, as my case, and as a lawyer, I've been involved in the most important plannings in the judiciary branch in Brazil. Even when we consider Article 116, paragraph 1, that establishes a specific norm against dissimulation, even so, major companies are fined or penalized because there should have been an opinion that was not stated in the law, that they should have done an operation with people out of their economic group when Article 20 of Decree 1991 established that there is a premium resulting from operations done with related parties. Well, I would not go too far with this, but even if we have a more specific laws and precise, even so, we also have penalizations that are very subjective. And many times they use all these vague and generic categories handled by the doctrine. So if you go to examine all the guidelines related to tax planning that should be aggressive, or the purpose test, and all these general rules or general clauses, we're going to see that they have a high level of generality. And another thing relevant is this: how taxpayers can follow something that they cannot understand. This is basic. Usually, norms are usually the ones that only aim to drive people to do something or not do something. And with the assumption that they do or not do something is all what the policymakers use to write the laws. Because otherwise, the person cannot just do or not do because they do not know what they establish in the law. And this means that the subject can only be motivated if they understand the object of that motivation. And when such minimal determination exists, there is a transfer of power to the executive branch bodies. Then I ask myself, what ultimately you mean about transparency, legal certainty, or mobility, and so on, accountability. These are wonderful words. There are comfy words. So we hear that and then we feel well, but they don't mean much with regard to what we have to do. I recall a language a philosopher Hikanati. He wrote a book titled Meaning and Force. As to the pragmatics of the performative statements, like in the case of law. So, meaning that you should do something, prohibiting or giving granting powers to, or allowing people to. These are the two things, meaning and for strength. Without meaning, it doesn't mean anything. And we have law guidelines that have no strength. And in some topics that are not understandable, if you don't have meaning or force or strength, there is no performative act. So this is something that must be addressed.
The last thing I would like to share with you is the following. Professor Schwery, I thought he was my friend, but before the panel, he placed food for thought with the following question. Do you think it's right to deal these international treaties, agreements, convention under the light and iron based on categories of those that deal with domestic law and veto or understand veto the use of general clauses that might be the base for certain fines, because by the end, according to Professor Schwery with the food for thought, the wording of international bodies, it's a diplomatic language. How is diplomatic language? I'll give you an example. Every time North Korea moves militarily wise, USA says the following: if something happens, there will be energetic measures. In answer, North Korea issues the following sentence: if this happens, there will be an answer with no precedence. And Russia, just looking what's happening, says that if something happens, the outcomes will be terrible. Iran, by its turn, some months ago said if it is attacked, outcomes will be horrible. And Russia said if Ukraine keeps on invading its territory, there will be harmful outcomes. No one says what's energetic, what is a terrible consequence. No, because this is diplomatic language. But if it's so, do you think these categories used by us on domestic law are fit for use, right to deal with this language, which is not by defect but arising from the vague and general quality? Therefore, it's an important question, and the first reaction I shared with my dear friend was in the line that said, well, good. Although we cannot deal based on CTN, how to interpret treaties? True is that treaties also in Western countries provide privilege to rule of law. Amongst other key principles, equality, and so regardless of using domestic categories, the fact is that the outcome must be similar. But there's an additional point, which was the subject matter of our talk, which is regarding the fact that the country will only waive its sovereignty when it's done expressly. This word, if I'm not mistaken, does not mean that you have to have a written document. It must be written on a general, vague fashion. I mean, express and explicit. It must be explicit. My frontier ends here. I waive my sovereignty to do such thing with a certain purpose in a specific way. Being this true, this being that key principles of rule of law and equality are sort of vague legal system through the law for international law of Western countries that adopt, not curiously, the same principle, and also being true that any, let's say, any opening regarding issues of sovereignty should be done explicitly. It does not seem to me that it would be wrong or mistaken to examine, not because it's domestic rules, but its categories compatible with these principles and guidelines. Last point, and very brief. I also see that there is an insistence in those studies I have analyzed regarding being these rules and norms, general clause umbrella, necessarily good because they allow dialogue institutional amongst those involved, and dialogue is a good thing. I think most none of you is against dialogue is something positive. And also I see that we have an insistence regarding these words, the comfy words, as I said, which are those that when they are read, it rises the feeling of transparency, safety, and so forth. This idea that dialogue is necessarily something good, and the idea that finding the middle way of things is necessarily good, with due respect, I think we should reflect on it. Dialogue is as good, it's good in the relation with privates, but to enforce apply law and I don't think necessarily. I was frustrated to know that the STF of Brazil declared the inconstitutionality unanimously or almost regarding the budget via PIX secret budget through the immediate transfer of money. So this STF declared inconstitutional, and the 11 ministers will talk with the leadership of Congress to say that they had to decide that way to find, after a dialogue, the middle term. But the law has to be enforced. How are you going to ask and almost apologizing to the national crows to state a mechanism that is contrary to the principle of transparency of budget? No, but it's important finding the middle way on this. So it can also be important in other areas, but not for law. If this was true, think about the following scenario. The precinct had to torture a suspect during 1 hour. The suspect says the guarantee to not be tortured for 1 minute. Let's do half an hour, torture this guy, and it's okay. Middle way and dialogue are issues that are very good for human relationships, but not necessarily they are good for the law. This anthropomorphic view of legal categories, I must admit that it causes me some wrong feeling. This was my humble words to try to contribute for this debate, and thank you very much for your attention. Thank you, Professor Humberto. Now I pass the floor to Professor Fernanda, who will talk of the relevance of guidelines, comments, positions, Brazil, the backstage of the almost access of Brazil to the OECD. So you have the floor. Thank you, Guilherme. I would like to start saying my thank you to IBDT, Professor Schwery, Rodrigo Maito, and Luis Flávio for the honor of being part of this Congress. I would like also to congratulate the table on the and the Professor Michael Lang. He was my guide in my PhD, and then talking about professors. After Professor Michael and Isabel and Humberto Ávila, talking about them is talking about after a more than sturdy theoretic basis. So many of the remarks in theory, they are not necessary anymore. So I would like to stress some additional elements, and starting with the guidelines. The angle of OECD will be through the technical way of seeing things without trying to embrace political aspects. We know it's a subject that was priority during the previous government. This government is analyzing advantages and disadvantages, but this will not be the eye to be adopted here, but based on the recent historic context, looking not only the past but the future possibilities, reflecting about any possible future solution, because regardless of resuming this process of accession, is the Brazil is in full process of convergence to the transfer pricing guidelines of OECD. Starting with the guideline, this was the subject more relevant within the context of accession process. The two were highlight. This is the first one and more relevant. What is asked today is, if Brazil does not join OECD, what's the relevance this will have in terms of tax international policy, in addition to economic aspects? And there's an important relevance. There's a trend of convergence of standards of OECD in a wider way. So to give you a concrete example, there's a possibility that's concrete of executing the MLI to avoid BEPS. Brazil and USA, the only two countries to decided to implement bilaterally measures set forth by this multilateral instrument. And based on the joining the guidelines, we start having language that's unified, allowing in an easier way the adoption of the multilateral instruments. So I started to think and conclude that the process would be easier once the main legislative change was adopted. Now, the process is not only about the law, but its effectiveness and practices, and therefore this subject leads us to controversies listed by the guidelines, especially its complexity, need to reflect more the interests of developing countries, and especially the dynamic interpretation of such guidelines. Now, going to the subject of complexity, it was addressed by previous panels regarding the outlook of the implementation, and here I tried to do just so look with a different perspective regarding the norms and rules regarding the secondary legislation. This building of rules and norms will allow Brazil to take into account an important aspect for developing countries, which is the simplification. There was a suggestion by OECD B amount of pillar 1 for basic activities of marketing activities and distribution in the country should take into account, but the B amount was not yet adopted. Not even pillar 1 reached a consensus, because it's difficult for 150 countries to reach consensus based on the set forth margin. This shows a trend of tax international policy, although it's incipient on the international field, of searching also for a simplification. The subject of simplification is part of a wider context, and now I start to the second point that's controversial, which is the need for such guidelines to be more oriented towards developing countries. But there's an argument saying that the developing countries participated of the inclusive board of BEPS. That could be something important regarding G20 of the last 10 years. The law 2, 10, and 13 were reflected on these guidelines. So developing countries took part in the debate regarding the guidelines and rules. Nevertheless, it is questioned the actual power of influence of these countries, developing countries, in an inclusive board or framework. Brazil especially had the condition of associate, therefore it has truly a power considerable regarding dialogue within the BEPS project. Furthermore, we have the practical practice manual that tries to address the special situation of developing countries. But recently, the OECD has tried to give more importance, uh, more effective interest regarding the needs of developing countries. Therefore, a recent example from last August was the work made by the Mining, Ores, Metals and Sustainable Development IGF Forum with practice guidance for establishing the lithium price, which is basically ore for energy transaction, and we know raw materials as ores. They are the subject matter of developing countries' interest, direct interest. So to wrap up the introduction regarding controversial aspects regarding tax international policies of these countries, thinking towards the future, what would be the possible solutions both for the complexity and also the problem regarding the interests of developing countries. So one could think about more effort in trying to build simplification measures, both international and domestic scope, revenue, the excise that looking for safe harbors for specific transactions. But beyond this, we could also think about our international scope as Mount B Pillar 1. And additionally, both OECD and UN try to expand and improve the guidance that would be especially useful for developing countries. Example of the recent guidance. Now starting with the controversial aspect regarding interpretation guidelines for transfer prices, they reviewed but talking about recent versions for the interpretation of domestic legislation. Now under the international guidelines are in the same interpretation value as comments to Article 9 of the Model Convention, except for the double taxation agreements that parts explicitly refer to the guidelines in the protocols, which are legally relevant and binding, in fact. Now, as for the domestic legislation of several countries refer to the guidelines of OECD, normally setting forth that they should be taken into account regarding the interpretation of domestic rules. In Brazil, the normative ruling 691, the guidelines and its future amendments, especially approved by the Inland Revenue, the subsidiary sources for the interpretation and integration of transfer price controlling rules, except contrary or inconsistent with the law, and several normative rulings. And so it was included a dynamic interpretation, but it was sort of mitigated depending on approval by the Inland Revenue bodies. You can question this option, as Brazil is not a member of OECD. We don't know if we'll become a member. Nevertheless, by the end of last year, Brazil used to be participant. Now it's an associate member country, so entitled to vote regarding debates on guidelines. So I can go and work in Paris C as a representative responsible for the subject. So it's a different situation compared to further developing countries. On one hand, the use of the recent releases, it's key under two aspects. The first one, for the country to be updated regarding the practices of transfer pricing for control. but especially regarding in order to have an agreement in the interpretation amongst the different countries, granting rule of law, forecastability, companies under GI that's international. Therefore, although at first it might be thought that there will be a violation to the rule of law, if the constitutional principle of it is analyzed under the international eye, for the companies, it's be good to have an agreement amongst the understanding of different countries. So it's something similar, doing an analogy to the principle, or more technically, the objective of joint interpretation of double taxation agreements, which is looked under the eye of Vienna Convention Article 31 that foresees that agreements should be analyzed according to their purpose. And the purpose of the transfer pricing guidelines depend on the agreement of according to interpretation amongst the countries. We can also think about the need that the inland revenue should approve. Such approval, the RRF does not have the capability of supply the principle of the the legal system through the law. There's a need. There have disagreement, inconsistencies, or any sort of conflict regarding domestic legislation. Nevertheless, this approval by the IRF is very important as the excise per se, that first will do this analysis of any contradictions or inconsistencies, supplying more legal system through the law to taxpayers, and learning based on the example of Colombia, that this interpretation, automatic interpretation, i.e., automatic use of guidelines for the interpretation purpose, was stated as not constitution. The argument that Colombia was not part of the OECD, but in Brazil, although Brazil was part of it, the use of a report automatically might lead to some controversies, and even regarding the outlook adopted, which is the approval by the RRF, does not mean that it will not be generated many controversies. This is because there will be a control of legality, which is the legal system through the law of the guidelines through the RRF, but it's not an activity of it will be an interpretation activity, and taxpayers might understand different regarding compatibility between guidelines and law. Interesting that in this point to say domestic law is quite detailed, favoring at first the understanding of the legal system through the law. So it's a facilitated, even though many issues might arise from it. And therefore, it's very important that the inland revenue RRF, a practice quite common on normative ruling, which is public consultation. So we have a dialogue with the taxpayers, and they, by their turn, can say if they understand the new guidelines and releases as compatible with domestic legislation, as they could not provide new obligations to the taxpayers abiding by the legal system through the law. Therefore, because it's not possible to innovate, the normative rule will have the condition to say that there's no innovation, or the need, if there's innovation, there's a need to amend the legality. The instrument normative ruling might say there's no interest in changing this legal point, but it will say which part of this new version are applicable and compatible with the legal system, that it's a domestic legal system. This is an issue that was addressed in European courts. Some did not refer to guidelines to avoid controversies on the subject matter, but they adopted the interpretation compatible with the guidelines. and probably it will generate also several issues, legal issues in fact, that will be highly complex. But at first, we we have to comply with the legal system through the law and the resolution regarding subsidiary. It's foreseen that there might be those cases where the guidelines will innovate. Professor Lang mentioned that comments many times are not only a way of explaining things. And here, making a distinction for the guideline situation, many times the new releases, amendments, in fact, only explain and more details regarding the enforcement of the arm's length principle. And if so, there would be no incompatibility with the law that presented the fundamental parameters. Therefore, at first, the norm meet complies with the legal system through the law, then, and take into account the international dimension. It's important to have this dialogue with taxpayers in order to guarantee that this interpretation by the RRF is shared within the possible with all with the taxpayers, avoiding disputes that would be extensive disputes regarding the subject. Now, talking about the comments, as one knows, they serve the interpretation and enforcement of agreements. Briefly, I would like just to bring a new eye regarding the comments provide also history, notice, and divergency that many times might be important, up to the point that the comments will provide an option, which was what happened the income of services on '08. And with this divergency is important. In fact, there are three layers to be understood, which is interpretation divergency, the fact that that norm does not meet the interests of most countries and the interests of these countries, like those who import capital. And following this situation, it is important that the convention models supply options to the countries in a fast pace. We have noticed that even the extension of the governing, income, like happening with income technical services, even abiding protocols might result in controversies. As example, would what we be analyzed in the next panel, talking about technical services, repetitive resources. And just to wrap up, it's very important the work that the UN will develop regarding income arising from services. And going to the main subject of this talk, any accession process, Brazil's position regarding it must be and trends to be, if we are current on the reserve what's possible as suggested by the OECD and other members do, like USA, as only 6 Brazilian agreements do not foresee the new Article 12A or 13 UN for Brazilian agreements and protocols. One from Sweden is already being renegotiated and want to be executed, and this trends to happen with the further one. So I would like to wrap up just with the observation regarding the future outlook regarding both subject with session, which are the guidelines and the comment, in the sense of showing a involvement of the tax international policy that might reflect on reserves by the countries. Thank you, Professor Fernando. Due to the time, Professora Clara will address now a hot topic, which is the relevance of comments under the eye of the taxation of technical services, which is pending regarding judgment by the court. Clara, you have the floor. Thank you very much. Well, first I would like to, as a lecturer, as the chairman, I would like to thank the invitation made by Professor Eduardo Chueri, Maito, and Flavio. It's good to come back to the house that for so long I was part of you. I'll be brief due to the time. It was asked to be part of an honorable table with so many professors and famous professors, and then wrap up showing the outlook of Brazil and take into account Professor Lang's speech and Brazil's and the role of guideline comments according to our Supreme Court, and it heads towards saying something that is irrelevant, is necessary, and I do analysis that's absolutely subjective to assess the negotiation that's done by the parties. With this in mind, what's the problem? Just positioning us in what's happening in the Supreme Court that's affecting the subject for the decision regarding its repercussion. Repercussion not, repeating. The point is defining as technical assistance and services when those tech transfer must be subject to Article 12, 22, and 7. And we will see 21 do here with historical involvement of the inland revenue development understanding on the subject. So, Supreme Court, they have 3 on the subject. August decision ruling. Just published this ruling. We have 2 appeals affected by the subject under different Brazilian agreements: Brazil, Canada, China, Italy, Sweden, Israel, Argentina, and Portugal. Both will be soon analyzed. What's the first point important to be quoted? Supreme Court will analyze all subjects jointly, understanding any and all mentioned in the protocol for technical services, technical assistance. It's sufficient to lead to a certain interpretation. Brazil have several clauses, very specific and different relations. We have agreements without these sort of services equal to royalty. We have the more simple that limited both services. This is a translation from Portuguese, so it's not the original translation. And the more complex that mention technical service, scientific, administrative, and similar services of administration, of consulting services that are specific consulting services. And we have here, as Fernanda mentioned, clause that these have broader definitions. And here 2 big models. Protocol 1718 Protocol Argentinian, with a close definition to a normative instruction of the inland revenue, and we have the Article 3 being replicated in different agreements. Important to understand, not only we have several wording models that are in the protocol, but sometimes the same countries have different wording with time. Argentina in 98 had a wording that we mentioned, which is more simple, and now we have in 018 a wording that follows Norway. Soon we have a wording close to Article 13. And the question one would do, and the argument that perhaps have to be analyzed, is what the normative rule context when in history, and very straightforward, when conceived most did not have the understand of the RF on the subject, but a concern of the federal government pegged to tax planning regarding dividends and payments made to related companies. It was very specific context and proper for the time. This is the historical moment at that time. When the IRF analyzed the subject in 2014, there were substantial changes in the context. And the point is, ever the intention by the excise of Brazil was to adopt the interpretation that's in the RF. And more, this notion is clear when you see the involvement of treatment by the Federal Revenue Service in the time frame. At first, Article 21, 22, saying technical services, they fall within this. They are not in Article 12, but REF lost, and when the loss in the Supreme Court, it changes its understanding. You're not in 21 and 22, it's 12 now. The question, we're always on the 12, the own RAF change position with time, so agreements don't have the same wording more. If I update the wording of agreements with time, will change the agreement of Brazil, Argentina, Norway, and so what can we anticipate from this landscape? The truth, a long time it was analyzed, and the RF was too much on the 22, and it lost in the appeal on the Supreme, and taxpayers were ruled in favor. Now, expectation now is to be losing. A thesis advocate on how hybrid it is. It's what other states are doing. Will someone levy tax? If no one's levying tax, I will levy it. It's not written. Or a second interpretation, no, the mention on the protocol is enough. And interesting to see, it's the last ruling in 023 for Motorola case. Both Minister Justice, the two justices, and the model convention is not relevant. I sorry, professor, but it says that it's not relevant, the model convention. And I have to see the negotiation amongst the parties. And such, interesting to say, they are not in the vote. It's not clear when this was done. If any on this room asked the revenue, all the dealings following the protocols you check, none will mention the subject. I did the test, I guarantee none mention it. And the question is, where do we stand from now onwards? What to wait from this scenario? And the arguments the Supreme Court will support itself. Tax authorities will say very simply, I mean, the argument line is simple. It's not ordinary, but it's a simple argument line. The protocols are part of the convention. As such, it has a meaning. Protocol says technical services and technical assistance. If this is the definition and not limited when there's no tech transfer, I would not be subject to all and any contracts of technical assistance and technical service would be understand within the norm. And the taxpayer, by its turn, will say, look, historical and systematic interpretations, the model convention has a role here. Brazil has adopted the model. There was a definition of royalties that subjected would imply intellectual property and tech transference. And the understand advocated by the RF is a dynamic for you to build the meaning of it. Well, all this, and I try to be quite brief regarding time constraints. Where are we? What's our stand? Brazil confirms that it will be following the OECD model. We are now, but are we in fact? Perhaps the most controversial point we bear witness within the Supreme Court scope is model convention has no model. Negotiation by states follow parameters absolutely subjective, where just as they felt like this convinced that the argumentation there will be revenue loss as sustained on the block of the Justice Regina Helena Costa, the need to comply with BEPS and protection of tax collection should be protected, as it would adopt an interpretation that would be wide enough to understand within royalties mention all technical service regardless of technology transfer. If this is the understanding we will have, interpretation, rule of law we want to build of OECD standard that we want to adopt in Brazil scenario. The fact is that the Supreme Court now has a new challenge, the position of finally end the debate of long time, and it's ongoing in this country, how Brazil will deal and take seriously its conventions, as how much the domestic aspect will be an interpretation just for the purpose of tax collection. Thank you very much. Thank you very much, Professor Clara. We will follow the next chapters of this debate, and today we will have, by the end of a closing table, that Justice Rugel will talk about this OECD and Supreme Court. Perhaps the next Congress we will have taxation on technical services, taking into account what you have said. Professor Clara, I pass the floor so you can do the wrap-up. Due to time constraints, I think we are all hungry. I say this table is closed, and thank you for your presence. Thank you very much.